Is law? Law is a set of obligations and duties imposed by the government for securing welfare and providing justice to society. India's legal framework reflects the social, political, economic, and cultural aspects of our vast and diversified country. The process of making a law. 1. When a law is proposed in Parliament, it is called a bill. 2. After discussion and debate, the law is passed in Lok Sabha. 3. Thereafter, it has to be passed in Rajya Sabha. 4. It then has to obtain the assent of the President of India. 5. Finally, the law will be notified by the government in the publication called the Official Gazette of India. 6. The law will become applicable from the date mentioned in the notification as the effective date. 7. Once it is notified and effective, it is called an Act of Parliament. Types of laws in the Indian legal system. Criminal law. Criminal law is concerned with laws pertaining to violations of the rule of law or public wrongs and punishment of the same. Criminal law is governed under the Indian Penal Code, 1860, and the Code of Criminal Procedure, 1973. The Indian Penal Code, 1860, defines the crime, its nature, and punishments, whereas the Criminal Procedure Code, 1973, defines exhaustive procedure for executing the punishments of the crimes. Murder, rape, theft, fraud, cheating, and assault are some examples of criminal law. Civil law. Matters of disputes between individuals or organizations are dealt with under civil law. Civil courts enforce the violation of certain rights and obligations through the institution of a civil suit. Civil law primarily focuses on dispute resolution rather than punishment. The active process and the administration of civil law are governed by the Code of Civil Procedure. Civil law can be further classified into law of contract, family law, property law, and law of tort. Some examples of civil offenses are breach of contract, non-delivery of goods, non-payment of dues to lender. Common law. A judicial precedent or a case law is common law. A judgment delivered by the Supreme Court will be binding upon the courts within the territory of India. The doctrine of stare decisis is the principle supporting common law. It is a Latin phrase that means to stand by that which is decided. The doctrine of stare decisis reinforces the obligation of courts to follow the same principle or judgment established by previous decisions, while ruling a case where the facts are similar or on all four legs with the earlier decision. Principles of natural justice. Natural justice, often known as jus. Natural deals with certain fundamental principles of justice going beyond written law. Nemo judex in causa sua, literally meaning, no one should be made a judge in his own cause, and it's a rule against prejudice. Audi alteram partem. Literally meaning, hear the other party or give the other party a fair hearing. A judgment can override or alter a common law, but it cannot override or change the statute. Ministry of Finance. It is apex controlling authority of four central services, namely, Indian Revenue Services, Indian Audit and Account Services, Indian Economic Services, Indian Civil Account Services, and Indian Cost and Management Account Service. Ministry of Corporate Affairs. It is an Indian government ministry. It is primarily concerned with administration of the Companies Act, 2013, the Companies Act, 1956, the Limited Liability Partnership Act, 2008, and the Insolvency and Bankruptcy Code, 2016. It is responsible mainly for the regulation of Indian enterprises in the industrial and services sector. The ministry is mostly run by civil servants of the ECLS cadre. These officers are elected through the Civil Services Examination conducted by Union Public Service Commission. Ministry of Home Affairs. It is an Indian government ministry. As an interior ministry of India, it is mainly responsible for the maintenance of internal security and domestic policy. The Home Ministry is headed by Union Minister of Home Affairs. Ministry of Law and Justice. The Ministry of Law and Justice is an Indian government cabinet ministry. It deals with the management of the legal affairs through the Department of Legal Affairs. Legislative activities through the Legislative Department. Administration of Justice in India through the Department of Justice. The Securities and Exchange Board of India. It is the regulatory body for securities and commodity market in India under the ownership of Ministry of Finance within the Government of India. It was established on the 12th of April 1988 as an executive body and was given statutory powers on the 30th of January 1992 through the CB Act 1992. Reserve Bank of India. It is India's central bank and regulatory body responsible for regulation of the Indian banking system. It is under the ownership of Ministry of Finance, Government of India. It is responsible for the control, issue, and maintaining supply of the Indian rupee. It also manages the country's main payment systems and works to promote its economic development. Bharatiya Reserve Bank, Note Mudran, is a specialized division of RBI through which it prints and mints Indian currency notes in two of its currency printing presses, located in Nashik, Western India, and Dewas, Central India. RBI established the National Payments Corporation of India as one of its specialized division to regulate the payment and settlement systems in India. Insolvency and Bankruptcy Board of India. It is the regulator for overseeing insolvency proceedings and entities like insolvency professional agencies, insolvency professionals, and information utilities in India. It was established on 1 October 2016 and given statutory powers through the Insolvency and Bankruptcy Code, which was passed by Lok Sabha on 5 May 2016. It covers individuals, companies, limited liability, partnerships, and partnership firms. It attempts to simplify the process of insolvency and bankruptcy proceedings. It handles the cases using two tribunals like NCLT, National Company Law Tribunal, and Debt Recovery Tribunal. Structure: Indian judicial system. When there is a dispute between citizens or between citizens and the government, these disputes are resolved by the judiciary. The functions of judiciary system in India are regulation of the interpretation of the acts and codes, dispute resolution, promotion of fairness among the citizens of the land. In the hierarchy of courts, the Supreme Court is at the top, followed by the high courts and district courts. Decisions of a high court are binding in the respective state, but are only persuasive in other states. Decisions of the Supreme Court are binding on all high courts. A Supreme Court decision is the final word on the matter. 1. Supreme Court. The Supreme Court is the apex body of the judiciary, established on 26 January 1950. The Chief Justice of India is the highest authority appointed under Article 126. The principal bench of the Supreme Court consists of 7 members, including the Chief Justice of India. Presently, the number has increased to 34, including the Chief Justice of India, due to the rise in the number of cases and workload. An individual can seek relief in the Supreme Court by filing a writ petition under Article 32 of the Constitution of India. 2. High Court. The highest court of appeal in each state and union territory is the High Court. There must be a High Court in each state. The High Court has appellant, original jurisdiction, and supervisory jurisdiction. However, Article 227 of the Indian Constitution limits a High Court's supervisory power. An individual can seek remedies against violation of fundamental rights in High Court by filing a writ under Article 226 of the Constitution of India. 3. District Court. Below the High Courts are the District Courts. The courts of district judge deal with civil law matters, that is, contractual disputes and claims for damages, etc. The Courts of Sessions deals with criminal matters. On the basis of a pecuniary jurisdiction, a civil judge can try suits valuing not more than 2 crore rupees. Cases are decided based on the local limits within which the parties reside or the property under dispute is situated. 4. Metropolitan Courts. Metropolitan courts are established in metropolitan cities in consultation with the High Court, where the population is 10 lakh or more. Chief Metropolitan Magistrate has powers as Chief Judicial Magistrate, and Metropolitan Magistrate has powers as the Court of a Magistrate of the first class.